Nice to see you, Raffaele. The floor is yours.
Thank you, Nicole. It is a pleasure seeing you, Madelina, Aida, and having listened to Michal and looking forward to listening to very important interveners. I'm very, very happy to be back, if only remotely, at the Judicial Cooperation Center, which has been a stronghold of my previous experience in training. My request to you would be only concerning timing. It's 10:34. Our agreement was that I would speak 30 minutes. We have no room for the questions if we have to break at 11, I think.
I think we can have 5 additional minutes, okay?
Okay, well,
even 10.
Let's do that. So after Michal having covered with his usual vivid speaking a wide range of topics, I would very, very quickly address the general part of judges defending the rule of law under Article 6 of the European Convention. Of course, many of the things I will say were already implied in Mika's presentation. My starting remark is, of course, that I agreed on recording my intervention. I will be a little bit cautious in my freedom of expression, which remains also for judges. And in doing so, of course, I speak for myself and not for the court, since I'm a member of a number of compositions dealing with these issues in the past and possibly in the future. I will only limit my possible answers to questions, to those that are possible for me without negatively affecting my impartiality. So we are exactly, so to say, on our topic. So the role of Article 6 has been traditionally one of pointing to the need of fairness of the justice system in general, and the issues of independence and impartiality of the tribunal were, so to say, secondary to the general fairness need. Let me say that I wrote down in my slides here the reference to a fact sheet which has been prepared for the general public by my court on the independence of the justice system, which is regularly updated and which can be a reference document for your work. I must congratulate you not only on the hypotheticals that will be submitted to discussion today and tomorrow, but also, and that are not so hypothetical, I would say, just to make a pun, but also on the several materials and summaries that you have made. Congratulations to all of the team. But this fact sheet could be a possible addition to the list of materials that you've already prepared. So, as I was saying, fairness and independence appear both in the text of Article 6, but if we look historically to all of the items, I would say components of Article 6, which were under the focus of my court in past years, I have tried to list them in a rather clear way. So independence criteria, statutory independence by way of objective and subjective, and also absence of outside influence, but also objective guarantees as to career of judges, security of tenure, what other people would call irremovability, and also issues of civil and criminal liability of judges that could be linked to possible chilling effects on their independence were the typical topics that were covered by the case law of the European Court in Strasbourg. But there was a very clear subdivision of topics over our history. Because if you look, and I have tried to circle in red the topics that have been covered in the case law between the 70s and the 2020s, you see that basically you had cases concerning objective and subjective criteria of independence. You had the so-called doctrine of appearances being covered, and other ancillary topics such as the disciplinary proceedings against judges that were not really central. If you look at which of those cases concerned the role, for example, of high councils for justice, which are the bodies that in several countries, including some new democracies, started to be established in the mid-90s, whereas they were traditional only in some Western countries such as Greece, Italy, Spain, Portugal, etc. Well, if you have a look at that case law, you see that only in the Baca case and in two Ukrainian cases, you have the mention of what the role of these councils were. This was also rather natural because these councils were not widespread back in the early years of our millennium. If you have a look at the cases between 2020 and 2022 or 2023, we could also say, since we are almost finished with 2023, you see that there is a quick change of paradigm. You have that the case law switches in the listing of elements, of components of Article 6, briskly toward the idea that the core topic is the concept of tribunal established by law. Also, you have issues of quality of legislation dealing, and Michał already covered this under many respects, covering assignment of cases, covering the position of judges vis-a-vis reassignments. Madalina has already asked the question concerning that, which I tried to cover in an article of mine of 2022. But the idea is that there is this sudden change, and the role of those high councils for the judiciary, which was, so to say, very resilient in the previous decades, in this past couple of years, it becomes central, and it becomes central because of the role of these councils, but this can apply mutatis mutandis also to other bodies appointing judges, because they influence the concept of tribunal established by law. So the role of these councils, or the role of parliament, the role of a minister of justice, etc., is very, very relevant in defining the component of Article 6, which is represented by the concept of tribunal established by law. There is another similar shift in the paradigm concerning Article 6, and that is that the role of disciplinary proceedings against judges, which was already present in a few cases, as we said before, becomes central. And here we have seen that some topics were already covered by my by the previous speaker. Here, the idea is that disciplinary proceedings can be regarded as a way to impact on the judiciary by way of a chilling effect and by removing judges from tenure. Let me go very, very quickly on the way the case law of my court evolved. So it evolved, of course, on the basis of a re-understanding of Article 6. I will provide more elements in a moment. But between the 70s and I would say the late 90s and today, there were a number of new instruments at a worldwide level, but especially at the Council of Europe level. The first 3 bullet points in my slide concern the Council of Europe. So basically, you have the experience of new democracies for which standards had to be developed in order to reinforce independence of the judiciary. The role of a number of soft law instruments, some having a very, very peculiar way of emerging, in the sense that were judges themselves that found their standing in the Council of Europe and had their saying in establishing standards. My reference to the Magna Carta is only the last reference to a whole list that I cannot make here, and also the role of the Venice Commission, which provided a number of studies and suggestions that were very, very important, especially for new democracies. And then, and this is where Mikhaus Bobek's point would come into the picture, the case law of the Luxembourg court. After the Portuguese Judges Association case, which I had an opportunity to comment on at the very start of the work of our Judicial Cooperation Center at the European University Institute, the Polish cases provided a solid basis for the Strasbourg court to work on the issue of the role of judges defending the rule of law and what judges would represent as an infrastructure. So I introduced this concept of infrastructure, and I'm now coming, so to say, to the mid of my little presentation, which also requires a little theory being set out. We had the background that I just mentioned. So we had the precedent, which is in some way a parallel to the what the Portuguese case represented for Luxembourg. We had this Icelandic case that everybody knows of, I'm sure, which created a number of criteria. Actually, we call it the Austrason test, but there is more than a test in this judgment of 2020, which concerns the issue of flawed appointments of judges. Basically, in a regular case concerning a violation of traffic legislation, a judge is appointed irregularly, and my court is called at the level of Grand Chamber to assess what the consequences can be from the point of view of compliance with Article 6 if a judge is appointed out of domestic criteria presiding over the appointment of judges, and nonetheless this judge sits on a case. Of course, you can see what the connection with Polish cases can be, but we have this case concerning Iceland, which is the precedent to be referred to. There was then, after Astraudson, there was an article by our former president, Robert Spano, in the European Law Journal in early 2021, which clarified in some ways the scene. And there were some other public discussions in which we participated as a court. So we were exercising our freedom of expression in clarifying a little bit what the scenario was. And the scenario is, and this is probably the only relevant thing that I will try to say in my little presentation today, is that basically the Astraudson criteria, first of all, are compliant with our new understanding of subsidiarity after Protocol 15, because the architecture designed by Article 6 is redefined under the idea that in order to guarantee Article 6 and other articles of the Convention, you need an infrastructure which is constituted by a European dynamic community of judges, composed of national judges and European judges including both Luxembourg and Strasbourg, in a symbiotic relationship. Then Robert Spano's article clarifies a theoretical construction which I cannot comment today, but the idea is also that the rule of law, and especially Article 6, includes not only general principles, but also specific rules that it is for domestic court and European courts to enforce. Among those rules, which of course are prerequisites for the operation of the rule of law and fairness of proceedings, there is one, and that is that transparent, democratic, and non-party partisan mechanisms must be enforced in order to guarantee appointments and professional status of judges. These guarantees can be provided by several bodies, by tradition, by the parliament, by national councils for the judiciary. But even if there are national councils for the judiciary that are theoretically under the task of guaranteeing independence of judges, the functioning of these councils, or in the Icelandic case, the functioning of the relationship between minister and parliament. So this was a difference between the Icelandic case and the Polish case, can be flawed. It can be defective. And if it is defective, then it is for the European supervisory body, that is the European Court of Human Rights, to go and see if the applicant has seen both the fairness of proceedings and the independence of the tribunal by way of its not being established by law violated. So it is for my court, and probably also for the Luxembourg court, to pierce the veil of the facade of merely formal judicial independence. There is one empty hole, and I'm concluding on this conceptual framework, and that is the relationship between the violation of the rule of law in the area of judicial independence and the underlying domestic proceedings. I'm sure that the audience will clearly perceive the connection that exists between this empty hole and the issue that was raised by Michał Bobek on he said, what's next? How do you correct those flaws once that they took place? I would not comment on this, but I would list this as a problematic and very, very interesting point. Okay, I think I have a little less than 10 minutes left, and at this point, I would only show on the screen the list of the so-called Polish cases that were decided upon by my court starting in 2021. What we have is the picture of cases in which the court says that some bodies, including the Constitutional Court, are not constituted or established by law. This was the first case, Xeroflor. Then you have another list of cases in which you have judges that are taken away from their posts, either by way of termination ipso jure, by way of legislation, and this is the case of Grzenda, in which one elective members of the High Council for the Judiciary sees his term of office terminated by law. This is the case of Broda and Boyara, in which two vice presidents of courts are prematurely dismissed from their office, again by virtue of new rules on appointment of chief judges. Then you have cases in which you have both lawyers and judges that undergo disciplinary proceedings, and especially in these disciplinary proceedings, in which you have a judicial review guaranteed by a specific chamber of the Supreme Court established under the new legislation of Poland in a way which was not compatible with Article 6 and the concept of tribunal established by law, you see that the general disciplinary proceedings are flawed. Then you have also general cases, and Dolinska, Ficek, and Odzimek are an example, in which you have a regular civil case with a disciplinary with an appointment of judges that was in itself flawed. So you have a whole list of new cases which develop a lot on the only real precedent we had before the Icelandic case, which was this precedent of the Grand Chamber that everybody knows, Baca versus Hungary of 2016. After this list, which continues with some other important cases, I've heard that Jurek has been already mentioned by Madalina, and Madalina and Jurek entails a further step. Jurek is a case of freedom of expression of judges in which you have a termination of judicial tasks that once more are not the core task, because this judge is, so to say, fired from his position as a spokesman for the National Council for the Judiciary. Then there is also immunities lifted and other suspensions and other things in this case and in other cases. But the idea is that the court says in Zurich that in under some circumstances, the possibility for a judge to speak defending the rule of law is not only a right but also a duty, and there should be no disciplinary measure against this freedom of expression. So a very, very important case that sets out the scenario for the future. I included a case which dates back to only a week ago, this Pajak and others versus Poland. This is a violation of the right of access to court by applicants that were women, for which there was a discretionary refusal of extension of their terms of office, which was not provided for men, and for which no reasoning was given by the competent Minister of Justice. Again, since there was no judicial review afforded in most of the cases in Pajak versus others, the court found a violation. Now, let me conclude by cutting on a number of other topics that I only call to your attention. And the conclusion is basically as follows. The development of the case law of my court has been, so to say, a second phase as compared to the development of the case law in Luxembourg. And Luxembourg, as I tried to say, provided us with concepts and with precedents that were relied upon. The other component, however, was the Council of Europe's own acquis, developed mostly by bodies producing soft law, without which, if you go through the reasoning of the Strasbourg court's judgments, there would be no possible developments, especially in the area of freedom of expression, judicial appointments, assignment of cases, early termination of mandates, even if only partial mandates, not removing the judge from office as such, but only removing the judge from specific tasks, such as being a member of the Council for the Judiciary, such as being vice president of a court, as we have seen in my little and very quick overview. Now, the reflection is, what has been important has been this symbiotic relationship between judges. And what is more important is that relationship with the infrastructure. And with this reflection on infrastructure, I would really conclude. In one case, which is still pending and on which I intend to make no possible statement, but there was a press release of the court. It's the so-called Vrobel case. The European Court of Human Rights started using its power under Article 39 of the Rule of Court, granting interim measures. Of course, we know that the Luxembourg court did the same under the rules presiding infringement procedures started by the Commission. But the idea is that our interim measures were intended originally only for core convention rights, such as right to life and prohibition of ill treatment. There were only a few precedents before Vrobel concerning Article 6, basically in the case of Öcalan and a few other ones. So the idea is that because of this Vrobel case, and because of another case concerning another high contracting party, which unfortunately is no longer a high contracting party, the Russian Federation, in the case of eco-defense, the idea that I perceive, and this is really my personal perception, is that if you do not have an infrastructure locally at the domestic level, that may be an independent judiciary that can bring cases over and create this European dynamic community of judges, or if you don't have, as it happened in the eco-defense case, an NGO which collects possible complaints to be brought by lawyers before the European Court of Human Rights, then the role of our court, the role of the individual application to the court under Article 34 loses totally importance. And so this is probably the core issue that I see that we should discuss in this very important seminar, for which, again, I thank having been invited to. Thank you so much.
Thank you so much, Raffaele, for the presentation, for the slides. And I think that if you can, they will be really useful for the participants. And thank you also for staying on time. So we are a little bit running late, but I think that we have a few minutes to collect some questions, if there are questions, and for some short replies to these questions. So I open the floor to questions. I think it's Federica again.
Yes.
So,
yes. Oh, is there anybody else?
Okay. I can't see for the question.
Okay, I will just wait because I was thinking of breaking the ice, but if it's someone else wants to start, I know that I both are I'm eager to participate.
You are abusing your position.
Okay. Now, thank you very much. I'm from Hungary. I'm Tamás Gerő. I can say I am among the good guys, but we call in Hungary like lawyers with the empire and the rebels lawyers. So it's a little different in Hungary. So I just wanted to ask one question about the constitution, because Hungary is special because of the government has 2/3 majority. So every act is determined by the government for the last 13 years. So just one example, that the homeless people have no right to live on the street, for example, and it's against the human dignity, the Constitutional Court said before, and then the government put it into the Constitution. So I just wanted to ask that, is it possible to attack the whole Constitution in front of an EU court, not just one act or one decision? That it's of course, I don't think that a homeless guy would attack the Hungarian Constitution in front of the EU court or in a Strasbourg court, but it can be an idea. For example, just one example, that only one political party made the constitution in 2010. So majority of the people didn't accept this constitution, although they modified it 11 times. So is it possible to attack at the European Court or at the Strasbourg Court the whole constitution of Hungary, you think?
Oh, okay. So I think we shall address this question because we have only a few minutes for the reply. So I think it can be for both speakers.
There are further questions here.
Okay. So please,
okay,
it's not a problem for me, but I know that there is a coffee break and problems with the catering. So please try to keep the questions and then the answers as short as possible.
Thank you so much. I would like to ask, thank you for your presentation, and I would like to ask you, do you see any threats or dangers for the tests of the court established by the law? Because before the evolution of the Strasbourg case law started, as you describe it, the test of the court established by law was relatively clear and easy to do. However, nowadays, when the new elements and new criteria became added to the tests seem to be less clear than it was. Do you see any dangers for the court itself and for the test in the nearest future? Thank you.
Yeah, thank you so much. A very direct question. Thank you for your very rich presentation. And it's a question on the enforcement of the decisions by the European Court of Human Rights. So when the court has decided that a judge is not established by law, what do you expect in terms of the enforcement? Should those judges be removed? Thank you.
Thank you, Aida, for this short and direct question. So I think now we can, I know there is another question. Yeah.
Sorry to be so late with my question. I'm from Hungary too. And concerning enforcing the decisions of the court, about this Becker case, which is mostly about the freedom of expression of judges. I know that there is always a follow-up year by year or 6 months by 6 months. And I feel that there are still issues, and so issues are growing and growing. And we also made a communication quite recently about to the Becker case follow-up. And I would just like to comment that, for example, the newly recently accepted Code of Ethics, which was accepted by the National Judicial Council, is heavily attacked by the President of our Supreme Court, and it is challenged by him at the Constitutional Court. So my question is, how can you follow up the decisions, and how can you enforce governments to who are really creative by challenging the decisions, like although they pretend to comply with them. So I don't know if it was to understand this question. Thank you.
Thanks. Other questions from the room? Cannot see. Okay, good. So the floor is to Raffaele, first of all.
Thank you. The first question was asked by the Hungarian lawyer Thomas. He did not give me the last name, but it concerned the possibility to challenge, and I understand in Strasbourg, the entire constitution as such in a European court. I would suggest that the question is more for Michael Bobek than for me. In fact, he was directly answering. Should I answer in his place? I would say that under EU law, for sure, you can complain in Luxembourg if any constitutional rule would impose not to apply directly applicable, I'm so sorry for this noise that I cannot prevent, directly applicable EU law and possible constitutional rules that prevent national judges from asking preliminary rulings from the Luxembourg court. The operation of the Strasbourg court as such makes it irrelevant, the question, because you do not challenge legislation as such. You complain about a violation of the convention. The second question concerned the concept of establishment of a tribunal by law and the Gudmundur Andri Atzrautson criteria. The intervener, and I share his view personally, said that the new test, this three-pronged test, which is contained in the 2020 Astrautson judgment, makes it more complex to apply the concept of establishment of a court by law. I may only refer to an article of mine contained in the Mélange Spano, which concerned exactly the Astrautson test. I also concluded that there are some critical points in this test. I made a list of possible items on which the test would have to be readapted. So, maybe I will make this article available to the participants so that we can have a direct answer. Concerning Aida's question, I'm grateful to Aida for asking it. Enforcement of judgments, how can you deal with these judgments that impact on the real core of the national judiciaries? And the Hungarian participants' question concerning freedom of expression and the aftermath of the Baca case, my question is, under the convention, under Article 46 of the convention, the enforcement of judgment is in the competence of the Committee of Ministers of the Council of Europe. So there is also a link with the court procedure, which is a sort of infringement procedure in a Strasbourg cuisine, but the main competence remains with the political will of the Committee of Ministers. For the moment, this topic is very, very delicate, and it impacts on the Polish cases and on the Hungarian cases. So you will understand if I would not say more. But thank you so much for your attention.
Thank you very much, Raffaele, for replying to all the questions in a few minutes. I don't know if Michael want to add something, even though the Q&A session is now recorded.
No.
Okay.
No being the answer to questions, and no being the answer to a question posed by the Hungarian fellow, whether you can attack the entire constitution at once.
Yes, and probably also to attack specific provisions like that in question. There is the problem of the trigger. So how to bring the case within the scope of EU law as a preliminary.
No, that won't be that difficult, right? I mean, from the point of view, if it passes the threshold admissibility test, it's admissible. What I understood, however, the question being is it possible to challenge the entire constitution in one at the level of its systemic legitimacy? There, I'm afraid the answer is no. But my question, which I'm not posing, is why would you need to if you can chop it to pieces?
Perfect. Okay, thank you very much. Thank you to the speakers, and thank you to the participants for the interesting questions raised.